Good evening, everyone, and welcome to our annual Court of Protection case law update. I'm Mary Rachel McCabe. I'm a barrister here at Doughty Street Chambers in the Court of Protection and Community Care teams. And I'm joined here in Chambers by Sophie Miles, who's also a member of our Court of Protection team. And joining us remotely this evening, we have Gamete, who is in Cardiff, having been in court there today. So we're very grateful to Gemma in particular for being able to join us this evening. So we're going to talk through some of the key judgments that have been handed down in the Court of Protection over the last year or so. No doubt lots of you will be very familiar with the judgments, but hopefully they'll nevertheless, this evening will provide a helpful refresher on the cases. So I'm going to go first with a few cases, and then Sophie will speak about some others, and then Gemma. And please do add any questions you might have during the webinar to the Q&A box, and we'll have time for questions at the end. So next slide, please. So I'm going to start off by talking about KL, which I'm sure most of you will be familiar with, but I do think it's a really important case to come out last year. And I know that we've lots of local authorities and ICBs attending this evening, and so particularly relevant for you, who will likely be the applicant in these sorts of cases. And this was the case where Her Honour Judge Hilder concluded that it would be unlikely that applications for the deprivation of liberty of 16 and 17-year-olds would be considered under the streamlined procedure. So certainly in my experience, there has been a huge influx of 16 and 17-year-old cases in the Court of Protection. So this case is particularly relevant. But I'm still certainly seeing cases made by public bodies on Form Copdall 11, which, as you'll see from the judgment, isn't necessarily wrong, but we'll take a look at what Her Honour Judge Hilder had to say about that in this case. So KL was a 17-year-old boy, diagnoses of autism and severe learning difficulties. He'd been known to social services since birth and subject to a care order. He'd been living with the same foster carers since he was 4 years old. And Bolton Council made an application for the authorisation of his deprivation of liberty under the streamlined procedure. So in other words, on Form Copdall 11. So Her Honour Judge Hilder considered the application on the papers, the Copdall 11, and she made an order taking the application out of the streamlined procedure, inviting the OS to act as litigation friend. And you'll see the reasons given by Judge Hilder for taking the application out of the streamlined procedure. And those reasons will be familiar to anyone who's been acting in a 16 or 17-year-old case in the Court of Protection. Certainly long before this judgment in KL, I was instructed in a number of 17-year-old cases where Judge Hilder had taken the application out of the streamlined procedure, and she'd listed reasons like those. So that's that P was 17 years old, subject to a care order, no family contact, and there'd be a transition to adult services within 12 months. And really for those reasons, P should be independently represented. Next slide, please. So when Judge Hilder made that order, the local authority made an application asking for reconsideration of taking it out of the streamlined procedure. And that application was considered at the first hearing, by which stage the official solicitor had accepted the court's invitation to act as litigation friend. And so the parties agreed that the issue had become otiose. But Judge Hilder nevertheless agreed to set out in a written judgment an explanation of her approach to be published for wider consideration. And that's the judgment of KL that we have now. And I would say, although I'm going to talk through a summary of the judgment, it is one that is, I think, worth reading in full, because it sets out a detailed summary of the relevant legal framework for 16 and 17-year-olds, including the COP rules, the Mental Capacity Act, the Children Act, and all the relevant practice directions. So it's a really useful refresher of all the relevant provisions. Next slide, please. So after going through all of the relevant provisions in the judgment in a really helpful way, Judge Hilder said that it is unlikely that the court would consider that the streamlined procedure in Practice Direction 11A is appropriate for the authorization of the DAL of 16 and 17-year-olds. But having said that, she said the court would be slow to criticize an applicant for seeking such authorization on standard COP 1 form, even where there's no apparent dispute. So the applicant might think that because P is a 16 or 17-year-old and because they've been subject to a care order, etc., even though there isn't a dispute, the application should be more rigorously scrutinized and therefore should go via the COP 1 procedure. But equally, the court would be slow to criticize an applicant for using Form COP-DAL 11 unless there's an obvious disregard for the intentions of the streamlined procedure. For example, a clear dispute or a failure to undertake the necessary consultations. So really, the court said you could use either form. The COP1 obviously has the advantage of being a much shorter form and it's somewhat more straightforward to complete. But the COP-DAL 11 has the advantage of setting out very clearly in a staged way all the necessary information that you're going to need to pull together as a public body to get a deprivation of liberty authorized. So there are advantages to both, really, and the court said that you won't be criticized as an applicant, whichever form you use, unless you've used Form COP-DAL 11 when you absolutely clearly shouldn't have, because it's obviously a case not suitable for the streamlined procedure. Next slide, please. So Judge Hilder then went on to set out her reasoning as to why 16 and 17-year-olds lacking capacity and being deprived of their liberty are factually distinguishable from other cases that go through the streamlined procedure. And she said very clearly, 16 and 17-year-olds are at a critical stage of their development. They're at the unavoidable cusp from children's to adult services. And importantly, she said in her judgment, and I was at a conference recently at which Judge Hilder was speaking, and she reiterated this point. She said it's much more common than for other age groups that authorization is sought for the use of restraint and/or sedation. And I've had a few 17-year-old cases before His Honour Judge Burroughs where he has echoed that concern that the court is seeing use of very heavy-handed restraint for 17-year-olds that sought to be authorized and that the court needs to be scrutinizing. So she also said that many of the 16 and 17-year-olds who appear before the court already have a lengthy history of family breakdown, challenging needs and broken placements. And she also made clear that outside of the COP, if a 16 or 17-year-old is to be lawfully deprived of their liberty, authorization from a judge of high court level is required. So really, it's important for any judge to be scrutinizing a 16 and 17-year-old circumstances if they're in the COP. Next slide, please. So continuing with Judge Hilder's reasons as to why the streamlined procedure isn't appropriate, she said, care orders, accommodation under the Children Act Section 20 add an additional layer of complexity. And so in these cases, there is often overlap between the MCA and the Children Act, and that's right, of course. And she made clear that a care order, an extant care order, is a marker of unsuitability for authorization under the streamlined procedure. albeit absence of a care order is not a marker of suitability of the streamlined procedure. So overall, given all of those features, Judge Hilder said not suitable for the streamlined procedure, or very unlikely to be, but also it'll generally be unlikely for the court to appoint an accredited legal representative in cases concerning 16 and 17-year-olds. And indeed, I had a case recently for a 17-year-old in the Court of Protection where an ALR was acting, and Judge Hilder then invited the official solicitor to act pursuant to that judgment, just because of the level of complexity which she had made clear in this judgment. And so the cases will be heard, certainly in London. The London cases are being heard by Judge Hilder or one of the other tier 2 judges who are now sitting on rotation at First Avenue House to hear these cases. Next slide, please. So that's the case in a nutshell. And I've just added some bullet points here about things to think about in 16 and 17-year-old cases, which are increasingly common in my experience. So especially in the regional courts, I'm finding that they are still being allocated to tier 1 judges often. And in those cases, I usually do seek transfer to a tier 2 judge. And I've successfully had it transferred to tier 2 judges if it's before a DJ, given the complexity. And you can cite Judge Hilder's judgment if you're making that application. As I've already said, the OS should be invited to act if they haven't already been, because the case isn't suitable for an ALR. Initial disclosure, as well as the usual disclosure sought in Court of Protection, deprivation of liberty cases. Education file is important, as well as an EHC plan, if there is one. It's important to bear in mind from P's perspective and also from the public body's perspective that the case will require input from both children's services and adult services. So there are going to be a lot of personnel involved, and also potentially CAMS and adult mental health services if there are mental health challenges. You should ask, if you're acting for P, for a transition to adulthood social worker to be allocated if they haven't been already, but hopefully they will have been. And sometimes, in my experience, multiple moves, unfortunately, may be necessary, because if P is 16 or 17 in a very unsuitable placement, it may be that they need to move to a new children's placement, but then when they turn 18, usually they can't stay in the children's placement and they'll need to move to an adult's placement. So sometimes those cases are tricky because they do involve multiple moves. Next slide. So that was KL in a nutshell. Next case I'm going to talk about is Reed G, and that was when the Court of Appeal considered injunctions in the COP. And the legal test to be applied. And again, I'm sure lots of you are familiar with this, but it is a helpful judgment, and it really summarizes very clearly what the law is in relation to the Court of Protection granting injunctions. So I've just added some of the background facts there. G, 27 years old, had spent her entire adult life in a children's hospital. And in the substantive proceedings, Mr. Justice Hayden had said she should move from the hospital to a specialist residential unit. And then it was hoped that she would move there for a period and then she could move home with her parents. But after that substantive judgment, the relationship between G's family members and the treating clinicians deteriorated, such that the family members were impeding the efforts to formulate a care plan to facilitate G's move. Next slide, please. And that's probably a familiar factual matrix to most of you, unfortunately not uncommon in Court of Protection cases, contested Court of Protection cases. So the public bodies filed an application for seeking an injunction against the family members. And there were lots of restrictions set out in the injunction. Again, fairly typical injunctions that are made by the Court of Protection against family members in cases such as this, for example, treating staff with respect, etc. Mr. Justice Hayden granted the injunction for 12 months, and then all 3 family members sought and were granted permission to appeal, which is why it went to the Court of Appeal. Next slide, please. So in effect, the court told us what we already knew, but it's good to have it confirmed once and for all by the Court of Appeal. They said, yes, the COP does have the power to grant injunctions under section 16.5, and that's both in cases where there is a deputy, but also in cases where the court has made an order under section 16.2a. And the court sets out very clearly where the power comes from and says where an order has been made under section 16.2a and a decision made on P's behalf, it's section 16.5 you then look to, which enables the court to make such further orders as it thinks necessary or expedient to give effect to or otherwise in connection with that order. So pretty broad provision at section 16.5. Next slide, please. And the court then made clear, and this is in line with the analysis in the previous leading case on injunctions in the COP re-SF, and the court explicitly said that when making injunctive orders, the court's exercising the power conferred on it by section 47.1 of the MCA, which says that the COP has, in connection with its jurisdiction, the same powers as the High Court. And because it has the same powers as the High Court, then the test for the granting of injunctions includes the requirement in section 37.1 of the Senior Courts Act that it be just and convenient. Next slide. So this is where the Court of Appeal went a bit further than re-SF, the previous leading authority, and the court spelled out what the just and convenient test is, and it said that it should follow the test as set down by that Privy Council judgment there, convoy collateral and broad idea. And so that the just and convenient test will be satisfied where 2 requirements are met. First is that the person protected by the injunction has an interest which merits protection. And the second is that a legal or equitable principle which justifies exercising the power to order the defendant or / respondent to do or not to do something. So then the court said that in G's case, those requirements were satisfied. And that's because her interest in the substantive order, in other words, the order that it was in her best interest to move placement, being given effect to, was an interest that merits protection. And then because of section 16.5, the court being able to make such further orders as it thinks necessary or expedient, then that by itself justifies granting an injunction to protect her placement, as the court had already decided. And the court made clear that that's not just G's case, that the test will be satisfied, will be likely to be satisfied in any case where an injunction is granted to prevent the court's decision under section 16.2a from being frustrated or undermined. So really the case puts beyond doubt the court's power to grant injunctions. And in my view, even in a case where P's deprivation of liberty, for example, is authorized by a standard authorization and not necessarily an order of the court, that test, the just and convenient test, will still be met if the persons against whom the injunction is sought are putting P's placement at risk. So the usual sort of injunction cases that we see in the Court of Protection. Next slide. I'm going to take this extremely briefly because I've gone over time. So the final case I'm looking at is the hoarding relevant information case, AC and GC, which is an interesting case where there were 2 Ps who both had hoarding disorder. and the judgment considered whether it was in AC's best interests to leave a care home and return to live at home for a trial period. But more importantly, the judgment sets out the relevant information for an assessment of capacity to make decisions regarding P's, items and belongings. And I've set the relevant information out in full on the slides there: volume of belongings and impact on use of rooms, safe access and use. Next slide. Creation of hazards. I'm not going to read all the text. It's very helpful to have it set out in the judgment, and you can take it away there on the slides. Next slide. Safety of the building and the removal or disposal of hazardous levels of belongings. So in my view, very helpful to have that now clearly set out in a judgment, because I've done many hoarding cases where parties have sort of felt their way and tried to work out what relevant information to include in a letter of instruction to an expert. Now we have clarity on what that should be. And that's also an interesting judgment because the court ordered that it was in AC's best interests to return home for a trial period. And the court made some comments about positive risk taking. So it's a useful judgment as a reminder to all of us to not take an overly paternalistic approach and to engage in some positive risk taking in P's best interests. I've gone over time, so I'm going to hand over to Sophie now.
Thank you very much, Mary Rachel. It's really interesting, actually, really interesting cases and useful analysis. I've got a couple of cases I'm going to be talking about, and then I'm going to just briefly look at the recent guidance on Section 49 reports that we've had. And the first case that I'm going to look at is A, covert medication closed proceedings. So clue is in the title, but what it's about. This was quite a shocking case in some ways, and it was quite controversial as well. And it's the culmination of several years of litigation starting in 2019. A was a young woman of 23. She had a mild learning disability, Asperger's, epilepsy, and she also had primary ovarian failure and vitamin D deficiency. And she'd always lived with her mother. And at the age of 23, she hadn't gone through puberty. Her mother had not taken any steps to have this investigated, which was described as highly unusual. And the evidence that seems to have emerged during the litigation suggested that Mother B was really sort of quite reluctant to actually allow A to grow up, and that was the kind of underlying motivation. So in 2019, Judge Moyer found that A lacked capacity to make decisions about her treatment and her residence, and that it was in her best interest to have the 100% effective hormone treatment, which would allow her to go through puberty and also prevent some very serious health risks that she would have been exposed to if she hadn't had that treatment. And A was going to be residing away from B with limited contact because of the concern about B's influence. So that was how things stood. Can I have the next slide, please, Larissa? However, although A was taking the hormone treatment, the public bodies became increasingly concerned that she was going to stop. And therefore, in September 2020, a hearing took place, which is described as a closed hearing. And essentially, no one was aware that it took place from B's legal team. Her solicitors weren't aware. She certainly wasn't aware. And the hearing wasn't reported. And it wasn't, although there'd been observers at previous hearings, there were none at the hearing in September 2020. And at that hearing, the judge approved a plan for covert medication if A started to refuse a treatment, which everyone thought she was going to do, and which indeed she did do. So continuing covert treatment was authorised. A started to refuse the treatment, and as far as A was concerned, she wasn't getting the treatment because she refused it, and nobody knew it was being delivered covertly, and nor did her family. She did go through puberty. She had visits by some members of the family, and it was a feature of the case that nobody sort of seemed to have asked themselves how that had happened. And in 2022, B sought her return home. And it became clear from some speculation in the Open Justice Court and Protection Project blog posts that, you know, there were kind of real questions to ask. You know, why, on the face of it, had A been away from her mother when both of them apparently wanted to live together for the purpose of having treatment, which everybody thought she hadn't had. And I think it became clear that, in a sense, that situation, you know, to continue to manage the case in the way that it had been managed was going to become unsustainable. The case was allocated to a Tier 3 judge, Mr. Justice Poole, and there were then 2 hearings, which we'll look at the next slide. Nerissa, please. So he had held a closed hearing in September 2022, and it's worth having a look at his judgment when he talks about, in particular, covert medication. And I'm going to come sort of remind us of some sort of an older case about covert medication before I leave this case. But essentially, he said that it is only going to be approved in exceptional cases. As of September 2022, A still lacked capacity and didn't want hormone treatment. And again, that was very much considered to be a result of the influence of B. Mr. Justice Poole said that the treatment was in her best interest, but sort of importantly, it wasn't quite as critical as it had been back in 2019 because it had been successful in helping her go through puberty. And therefore, he felt that the risks didn't justify continuing effectively to trick A into taking the treatment covertly. And he ordered that there would be a plan in order to kind of work out the transition towards having open treatment, which she would know about. So that was the closed hearing, and there was then an open hearing, which was going to be B's application to have A return home. And B was told at the start of that hearing, as were her legal team, well, this is what's been going on without your knowledge. And then obviously B had to then her legal team had to kind of reconsider their position in light of what they'd been told. And what the court eventually authorised was that A would continue to reside away from B, but they would begin to have face-to-face contact. And A would continue to have covert medication until a transition to open medication had been approved by the court. It was directed, obviously, that A would not be informed of this, but the judge considered very carefully whether it was appropriate to continue with a reporting restriction order, which prevented any reporting about the issues in the case. And he, in the end, discharged the reporting restriction order. And Ray, if we can go on, not Ray, Nerissa, if we can go on to the next slide, we can see his reasoning. So he acknowledged that there is a real public interest in the fact that the court occasionally does authorise covert medication, and that on this occasion, the family had been excluded from that decision. Of course, that might not always be the case in cases where someone's going to be medicated without their knowledge. He recognised that perhaps things could have been dealt with in a slightly different way when the closed hearings were being conducted. So one option might have been to allow the press and to allow observers to the hearing, still not to allow B into the hearing and not to have informed A about it, but then to have restricted the reporting until a later date. One of the things that I found quite interesting was that he didn't consider the sort of possibility of the sort of special advocate procedures that had been suggested in the Re-P discharge of party case in the Court of Appeal. That was a case where you'll recall that Mr. Justice Hayden discharged P's mother as a party to the proceedings, and the Court of Appeal said, well, that's really the last thing that you should do, and you should think if they've got sensitive material that you don't want a party to see, you take a staged approach. And one option is to have a special advocate who is in both the closed and the open hearings. After this hearing took place, there were numbers and certain amount of press coverage. There was quite a long article by Joshua Rosenberg, who also asked for a statement from Mr. Justice Hayden. And following this, he has allocated a subcommittee of the Court of Protection Rules Committee to sort of look into what the closed hearings in the Court of Protection and suggest some kind of guidance. I mean, it seems to me it will be inevitable that there will be some occasions where some form of a closed hearing is going to be necessary. But perhaps it will be helpful to have some guidance as to how what approach the courts should take and what stages they should go through. And I just wanted to just flag a much earlier case about covert medication in RM and St Andrews Healthcare, which was a mental health tribunal case where the patient was receiving covert medication, found out, stopped eating and drinking, got actually really quite seriously unwell. Covert medication started again, and the hospital wanted that to be not to be disclosed to RM at his mental health tribunal. And the upper tribunal said, you know, despite the risks to him of being told that he was covertly medicated, it was so important that he was able to present his case to the tribunal properly that it justified informing him of the existence of the covert medication. And I think that's just a slightly different approach to covert medication, perhaps reflecting obviously the different context, but perhaps it's just a case to be aware of in the background. So that's the first case I want to talk about. And then my next case on the next slide, please, Nerissa, if we can go to that, is EM. This is a case in front of Mr. Justice Mostyn. And what's rather quite interesting about it is there was only one party represented, that's the local, the public body involved. That was a trust, and AEM wasn't represented at all. The case had started off as a without notice hearing where an order had been sought to remove EM from his home. EM was 74, he was seriously unwell with malignant melanoma and brain metastases. And unsurprisingly, in those circumstances, an out-of-hours judge had been persuaded to remove him from his home so that he could have treatment. And then at the second hearing, Mr. Justice Mostyn was asked to authorise a move from hospital, where he no longer needed to be, into a nursing home. And again, EM wasn't represented. Mr. Justice Mostyn was informed that he objected to the move and he wanted to be at home, but that was really the limit of his participation. So the judge was clearly put in a position where there really wasn't much of an alternative to him, but he was clearly really quite unhappy about it, and said that he would write a judgment setting out his concerns, which he did. And he deals with sort of three concerns, but the first, and I think perhaps the one that I think is the most important, is the comments about the representation and participation of P. And if we can go on to the next slide, please, Larissa. We'll see sort of the kind of heart of his judgment after he'd looked at the various authorities and the practice directions that have sort of grown up over the last few years about how P should participate and the role of the accredited legal representatives, and whether P needs to be a party in any deprivation of liberty case. And what he says is that the golden thread runs through all the judgments and the practice directions and rules that the court must ensure that the participation of P is given careful consideration and promoted as far as possible. And whilst there may be times when the sort of urgency of the situation dictates an interim order without being represented, this should be exercised with special caution. And he actually says, you know, if you've only got one person in front of you, and that's the person that wants to deprive their P of their liberty, you need to approach what they're saying with a healthy skepticism, because it comes with the risk of confirmatory bias. So that's kind of, you know, really quite important thing to bear in mind if you're ever considering making a without notice application. And the other comment that he makes, I think, is very important. And again, Nerys, if we can go on to the next slide, please. He sets out a fundamental rule. So if an application is made which seeks the deprivation of P's liberty, P must be joined as a party and litigation friend or ALR appointed. And the only exception to that is where it's very urgently needed on an interim basis and there just isn't time to secure the representation before the hearing. But if that happens, it's absolutely essential to make sure that there is a return hearing and that P's representation and participation is guaranteed at that second hearing. So, you know, if you're in a situation where you've had to go to court without notice because of the urgency and you haven't been able to arrange participation for P for whatever reason, you absolutely have to consider it for the following hearing. And Mr. Justice Mostyn's view certainly is that if you haven't secured representation when you're making a non-urgent deprivation of liberty order, then that will very likely render the order unlawful. So that's something for everyone to remember. And then on the final slide for this case, there's a couple of comments, firstly about anonymising orders. And Mr. Justice Mostyn reminds everyone that sort of 10 years ago, he gave a judgment in a case called GU saying, really, we shouldn't be anonymising orders. It's very dehumanising. He then says in this judgment, well, nobody took any notice of that, but I really think it is a terrible practice. And he said it's utterly demoralising, patronising and insulting. And he imagined what it would be like to be a person who perhaps is quite close to capacity, whose case is being heard at the Court of Protection, and be shown an order that refers to you as G or SA or whatever it is. So that, you know, there's some real sort of thought to be given to that. And what his practice is he uses real names on the faces of the order and then has a reference to the transparency order as well, so that it's absolutely clear on the face of the order that there shouldn't be disclosure of names, addresses, etc. So, you know, that's again perhaps something to consider. It simply requires a bit more organisation, and of course the Practice Direction 4C anticipates that there will be anonymised orders when hearings are in public, so it might require a little bit more thought. Perhaps than simply changing one's individual practice. I'm going to be very brief on the issue of his comments on transparency orders. He does, thanks very much for going back. I hadn't quite finished there. His view, as expressed in that case, was they're a problem because the court is making them automatically and they're not weighing up the interest between the Article 8 interest in protection of privacy as against the Article 10 interest in the freedom of expression. I'm not sure that's entirely right. My reading of Practice Direction 4C is that what it anticipates is cases in private, because that's the general rule. Before the first hearing, a judge makes a decision that hearings will be in public, and at the same time imposes reporting restriction order. And Mr. Justice Charles, in a case called Reed C, Associated Newspapers and C, described that as being the court turning the tap on and not turning the tap on. So the court isn't restricting information, the court is actually allowing information, and that's rather different to the standard restriction order, which starts when a case is in public and information is being withheld. I've referred in the slide to a really helpful blog by Alex Rutkeen, who goes into this in a lot more detail, and it's really worth a read. Really quickly now on to section 49 update. And I'm actually only going to really refer you to this. There's been a letter recently from Mr. Justice Hayden asking everyone to think really carefully about use of section 49 orders because they're becoming overwhelming. And he's stressed, if you look at the letter, you'll see that he kind of underlines the bits of the practice direction that he thinks are particularly important. And those include really trying to limit the use of a section 49 order to cases where either the trust that you're asking to do the report is or knows the person or should have knowledge of the person or is going to be involved in some way. So the corollary to that, in my view, is when you're thinking about getting expert evidence, remember that practice rule 15 makes it clear that the court shouldn't be directing expert evidence in cases where a section 49 report could suffice. This seems to me to be saying, well, actually, there aren't that many cases where a section 49 report will suffice. It's not a quick and easy way of getting an expert report. If you've got someone who is not known to any specialist service and there's a question about that particular discipline, really, you should be going down the route of an expert report, an independent expert report, rather than section 49. That is all from me, and I will hand over now to Gemma. Thank you very much.
Thanks, Sophie. And before I start, just to check that you can hear me clearly. Yeah, nods. Thank you. So next slide, please. Next slide. Those are some slides that you'll get when this is circulated afterwards. So starting with the slide that's in the best interest move to Jamaica, this one. So I'm going to talk about 3 cases quite quickly. This first one was before Mrs. Justice Leven, and as the header says, is about a best interest move to Jamaica. So essentially this was a case with an 89-year-old man with Alzheimer's, and he was living in a care home in the UK. He was originally from Jamaica, but had been in the UK since the 1960s and had been here with his wife until sadly she died in 2016. He had some family through his wife's family, so step family in the UK, including a step granddaughter who held a lasting power of attorney for his property and affairs. And there were some issues that are touched on in the judgment about that, but we don't need to go into them now. He had considerable extended family, by contrast, in Jamaica. So his 2 sisters, 2 surviving sisters, nieces, and nephews. Next slide, please. And essentially, this was an application about whether it was in his best interest to move to Jamaica or to remain in the UK in a care home here. And the court considered his wishes and feelings, of course, as required by best interest analysis, both past and present. And the evidence before the court about past wishes and feelings related to visits to Jamaica that he had had since 2005 on 2 or 3 occasions. And he had, when he'd been in Jamaica, registered with the Jamaican Returning Residents Association, which the court took into account as evidence of his past wishes and his past intent to return to Jamaica. He'd also talked, when he'd been in Jamaica, about living and returning to stay there. And so those were the past wishes and feelings taken into account by the court in summary. During these proceedings, there was a Section 49 report from a Section 49 author, if we call them that, and the Section 49 author had said that he, XX for the purpose of the judgment plea, didn't understand about his family in Jamaica. The process, this stage of his disease, Alzheimer's disease, was such that he didn't have an understanding that he had family in Jamaica. He was limited in understanding when they called him as to who they were. And staff in the care home reported that he derived pleasure from the calls from his family in Jamaica. He seemed to know they were family broadly, but he didn't know them by identity as such. So his present wishes and feelings were certainly not that there was any express wish to move or go to Jamaica. And in fact, the evidence suggested that he appeared content at the current care home. So a difference between his current wishes and feelings, perhaps as they could be interpreted when he lacked capacity to make the relevant decisions, as compared with his past wishes and feelings about a move. Next slide, thank you. There were practical issues considered by the court, as you'd expect in these cases, about moving to a different country quite far away. And in his case, he wouldn't be able to travel in the normal way. He would need an air ambulance or aeroplane by air ambulance to travel. And that is, of course, a private arrangement that's very costly. And the family in Jamaica who were proposing the move to Jamaica as being in his best interests had put together, perhaps unusually, a very detailed care package proposal, which included as well a proposal for the cost of the air ambulance, which would have been about £100,000. And he had capital of £150,000. And I think for me, the interesting thing about this case, one of the interesting things about this case is the financial position, because sometimes I think people can jump to a conclusion that if someone has £150,000 and £100,000 going to be spent on an air ambulance, that doesn't leave them with a whole lot for their remaining care. However, the court had to consider, well, how much is he paying for the care home in the UK? That was £40,000 a year. And the family's proposal in that detailed care package in Jamaica would be far cheaper. There would be family involved as well as professional care, and it would be less costly than the care home where he was here. And Mrs. Justice Leven said that this is not a case where, in my view, money is the critical feature, as it could be set to cut both ways. So exploring that issue about the cost of the current care home, but the cheaper cost in Jamaica. And ultimately, she said there is enough money for his travels to be paid for and for there to be a pot of capital remaining for paid care in Jamaica. So the point that I think is helpful perhaps to consider in other cases is that just because someone doesn't have an enormous pot of capital and there is going to be a relatively expensive cost associated with a move, doesn't in and of itself necessarily mean that it's not going to be in their best interest for that money to be spent in that way. So moving to the next slide, please. The positions of the parties were that there was accredited legal representative for P, and said that the position was finely balanced, but came down on the side of him remaining at the current care home. The family in Jamaica, as I said that he should move to Jamaica, and they relied on his past wish to travel there before he lost capacity to make that decision. And the strong benefits he would get, they said, of his cultural and emotional needs by being surrounded by loving family, by music, culture, and religion in his home country. And the local authority took what the judge described as a surprisingly firm stance that he should stay at the care home. Next slide. Mrs. Justice Leven considered the case that might come to mind for everyone of re-UR before Mr. Justice Hayden in 2021 about a move to Poland. And in that case, cautioned, as many other judges have, against an overly paternalistic approach in the course of protection, and referred back to the very famous judgment of Mr. Justice Mumby, as he then was, in re-MM, essentially the final sentence there that we're all familiar with: what good is it making someone safer if it merely makes them miserable? And having considered re-UR, Mrs. Justice Leven made her, next slide, thank you. Mrs. Justice Leven made her decision in this case and acknowledged it wasn't an easy decision, and noted, interestingly, unfortunately for P, but interestingly for practitioners, that delay had somewhat diminished the ability for P in this case to gain from being in Jamaica. Delay, of course, for somebody with a progressive disease meant that he was at this stage, by the time of the judgment, unable to identify those family members, as I said. But nevertheless, it was in his best interest to move. There was a proposal at some point in the proceeding or in the hearing for further evidence on the cost and ability to fly to be obtained before a decision was made. But Mrs. Justice Leven said that she'd reached the view that, in fact, the principle should be decided first, and then we can consider what orders need to be made to expedite the move. And often in court protection cases with similar and with different issues, there may be a point where practitioners, we find ourselves maybe wondering how much detail do we need? Do we need that perfect amount of all the evidence we possibly can, weighed against the risk of delaying the decision for P, when that delay may diminish their ability to gain something from that? So an interesting point here that the principle should be decided in this case before the details about the expedition of the move. Next slide. So the reasons that Mrs. Justice Leven gave for saying that it was in his best interest to move to Jamaica included, as you'd expect, consideration of P's wishes and feelings when he had capacity, so that he had wanted to move to Jamaica for his final years once he'd dealt with his affairs in the UK. There was some risk associated with travel, but it was considered to be that it could be mitigated, as well as some physical risk to P. There was a suggestion that perhaps he could gain the benefits from his family in Jamaica by them visiting in England, but the court said no, that would not be the same as the benefits of actually being in Jamaica surrounded by family. And additionally, Mrs. Justice Lieven acknowledged importantly the intangible benefits that lie in the nature of human feeling and experience to spend those last years with a loving family around him, rather than being cared for by strangers in a care home. However good staff in a care home are, she said, they're not the same as being cared for by a loving family for whom the individual is special and has particular connections. What most people would want is to be with their family around them for their later days. I'm sure that will be cited in many cases to come for people proposing a move to be with family. Obviously, it's always case specific, but it's an interesting explanation of the point. And the other intangible benefits that he would get from being in his place of childhood included the smells around him, the food, the religion, the culture, the points that his family had made were expressly taken into account by Mrs. Justice Lieven. And then finally, just a note about the delay. Again, unfortunately, a comment on delay in court of protection cases, as is seen in family court cases, and about the impact on P. As Mrs. Justice Lieven said, it's common to refer to the impact of delay in Children Act cases, but the serious impact, I should say, on Ps in court of protection proceedings, such as XX, whose condition has deteriorated during the lifetime of these proceedings, is also of great importance. So a warning again to avoid that delay, as many judges have told us in recent years, as much as possible. Next slide. The next case is an unusual one, and it was an urgent out of hours application before Mr. Justice Poole. And it's a case that was brought by the parents of a relatively young man who was unconscious in intensive care following a sudden collapse. A very sad case, no doubt, and there's repeated references in the judgment to the very unfortunate and tragic circumstances that came before the court. And there was virtually no prospect that he would recover. And this case was all about his parents' application for a declaration of lawfulness for a doctor to retrieve his sperm and store that after his death to allow for the prospect of a family of children, biological children of his, to come into existence at some point in the future. Now, the court wasn't being asked to deal with the issue of what would happen after collection and storage, but if the application had been allowed, then that would have had to be dealt with later. So it was simply an application, given the urgency of the circumstances, for the retrieval and storage after death, retrieval before, of course. That's not very clear in that sentence, apologies. Next slide, please. In terms of his wishes and feelings, parents have given evidence that essentially he'd spoken about wanting children, and they said that they would wish very much to fulfill that wish. He had a girlfriend, but there was no evidence from her other than via the parents who said that they'd spoken to her. As I said, it was a very urgent and out of hours application. P hadn't made an advanced decision. And the court said that there was no evidence of his wishes and feelings that was relevant to the decision. And in my view, a very important comment from Mr. Justice Poole, that it's one thing to have a consistent and heartfelt desire to be a living, caring father. This is quite another thing to wish to have one's sperm collected and stored when unconscious and dying, with a view to the possibility of it being used for conception after one's death, and without having expressed any view when living about how the sperm should be used. So in terms of principles, I think the point that I take from this is that when we're trying to establish what P's wishes and feelings are, clearly those wishes and feelings can be difficult to ascertain. I mean, in circumstances like this, you can't ascertain the current wishes and feelings, but even finding out what a person would have wished for, it's always going to be relevant to the decision before the court. And there may be some nuance about what is exactly that decision before the court and what wishes P has expressed. So perhaps a reminder of, even when obtaining those wishes and feelings, ensuring the accuracy of them, because they will be relevant, so that they are relevant to the specific decision the court is looking at. Next slide, please. There was involvement of the Human Fertilization and Embryology Authority by way of a letter. They didn't appear in court. It was sort of, given the urgency of the case and being out of hours. But essentially, the position of the HFEA and the official solicitor P were that they opposed the application by the parents. The NHS Trust was neutral. And essentially, the HFEA, as I read in the judgment, sort of emphasised the importance of consent under the Human Fertilisation and Embryology Act. Next slide. So the application was refused, and Mr. Justice Poole said if the Court of Protection were to routinely authorise the collection and storage of gametes in cases where there is no or little evidence that the incapacitous dying person would have consented, then it would undermine the regulatory provisions within the 1990 Act, which require actual consent. And there was consideration of an interim permission, permitting the application on an interim basis, but it was dismissed as nevertheless being an invasion of P's privacy, and it would be an interference with his Article 8 rights that was not considered by the court to be necessary, proportionate, or in his best interests. Next slide. Some of you may be familiar with the case of Y from 2018 before Mr. Justice Knowles, where in that case there was an application somewhat similar in that it was for deprivation of lawfulness and it being in the best interest for the sperm of a person to be retrieved and stored prior to their death. The difference being, and the way in which it was distinguished by Mr. Justice Poole in this case, was that that application had been by the applicant's husband in Y, and in very different circumstances in terms of P's wishes and feelings. So if you read the case of Y, you'll see that the couple were undergoing fertility treatment. These issues had been discussed. The relevant wishes and feelings had been obtained. And that's really a summary, as best I can put it in the time available, of how the case was distinguished. But you've got a full quote there from Mr. Justice Poole. Next slide. I'm going to talk very quickly, finally, about the case of KF. And this is a very sad and exceptional case. This is another case before Mr. Justice Poole, and it relates to coercive and coercive control. KF was a 34-year-old woman with a learning disability, and she'd been in a long-term relationship with a man called identified as KW. And there were all sorts of records relating to coercion and control, taking her money, overbearing her decision-making, and violence against her. And there was a very violent sexual assault by KW against KF, for which he had been convicted. And he was awaiting a sentence that was likely to be a period of time in prison. Now, the criminal court had not imposed any bail conditions on him pending sentence, and therefore he could, in terms of not having any bail conditions, could have had contact with P. So the Court of Protection had to consider, first of all, whether P had capacity to make decisions about that contact in that intervening period, so pending sentencing, given that he was very likely to be in prison afterwards. And if she lacked capacity to make decisions about contact, whether such contact was in her best interests. And additionally, if she had capacity to make decisions about engaging in sexual relations with him. Next slide. And she was living in a care home at this point, and very sadly, KF had been diagnosed with metastatic breast cancer with a poor prognosis. And the prognosis was such that the prison sentence of KW may well exceed her lifetime. So the application before the court was not only contact in that intervening period until sentencing, but really the last possible contact that she could have with this man, who she very clearly wished to have contact with, notwithstanding the coercive control and violence from him. And it was her very clear wish to spend time unsupervised and overnight with him before sentencing. She said she misses him and that she wants to hug and lay next to him. And she was very clear that one of the purposes for which she wanted to have contact was to engage in sexual relations. Next slide. And the court had capacity reports from Dr. Miners-Wallace, complex capacity issues. I don't have time to go into them now. The key point that arises on capacity, next slide, is that the court decided that there were two very specific decisions. The first being to spend private unsupervised time with KW, including overnight, and the second to engage in sexual relations with KW. And as you'll see, that's a person-specific capacity decision in relation to sexual relations. And in this case, the court was very clear that person-specific approach was appropriate and it would not be appropriate to take a general approach to it. And the court concluded that she lacked capacity to make those two very specific decisions. Next slide. And framed in that way, the court had no hesitation at concluding that the lack of capacity. And there's some quotes here from the expert in the case about how she was unable to retain information and unable to weigh up the reasonably foreseeable consequences, essentially not retaining the information or weighing it about the assaults and the risk to her. Next slide. The case distinguishes, or Mr. Justice Poole distinguished from the TZ number 2 case that you'll all be familiar with. So the circumstance where someone has capacity to decide to engage in sexual relations, but lacks capacity to make decisions about contact. And then there may be a best interest decision about contact arrangements. Of course, no best interest decision about sexual relations because he has capacity in those circumstances. So this was not that scenario. This was two very specific person-specific decisions about contact and sexual relations with one individual. Next slide. And given that she lacked capacity to make decisions about sexual relations with that individual, of course, no best interest decisions could be made. But in relation to contact more broadly, the court did consider and decided that any form of unsupervised overnight contact would not be in her best interests, perhaps unsurprisingly, given the history of the case. And that is everything from me. I don't know if we have any questions. I know we've run over or sort of got to the end slightly. If anyone has any questions, pop them in the Q&A. Otherwise, Sophie or Mary Rachel, don't know if you can see any.
I can't see any. The chat, is that's something else? Those aren't questions, are they?
I think those are the main.
Okay.
Yeah.
Just one question I had for Sophie, who sits now as part-time judge at First Avenue House, is for the 17-year-olds and 16-year-olds, Cop 1 or Cop Doll 11? Which one?
Yeah, tricky one, isn't it? Because I think it probably should be a Cop 1, because otherwise I think there is a risk that it's going to be sort of put in the wrong ground. Yeah. And I think the court is pretty good actually at, as the case law has shown, at kind of picking out the cases where they're clearly a Cop Doll isn't appropriate.
Yeah.
I suppose the other thing you could do is simply say, do a Cop Doll. The advantage being it sets out exactly what information the court needs, but make it absolutely clear that you want an oral hearing.
Yeah.
And with P to be represented, because that's the key distinction, isn't it, between the Cop Doll and Cop 1. So I think, do what Judge Hilda says, basically. But if you do go down the Cop Doll 11 route because it's easy for you to gather the information and present it in that way, then say big letters, 16, 17-year-olds, oral hearing needed.
Yeah. I see someone has asked if the slides will be provided. Yes, of course, they will be emailed. Gemma, are there any other questions?
I don't think so. And we've run over, so we probably should stop there.
Yes, sorry for running over.
Yeah, thank you all very much for your patience and for listening. And we hope to see you at another of our events soon. We will be. We have got a couple of forthcoming COP team events up our sleeves, and we'll let you know about them as nearer the time.
Thanks very much.
Thanks, everyone.